This Easter, my daughter-in-law formally uninvited me from our family dinner. She thought it was a power move, a final statement about who controlled the family. She had no idea what was coming on Monday, because when the property deed arrived, it wasn't her husband's name on the title. It was mine. And with one signature, her entire sense of security evaporated. My name is James Callahan. For 23 years, I watched my son build his life in the home I bought for him. To his wife, I was just the old man in the guest house, a benign fixture. She never asked about the deed. She just assumed. That assumption fueled every decision, every slight, culminating in that formal exclusion from our Easter table. She was about to learn the hard way that in families, like in property law, assumptions are not facts, and I was done being silent. It started with the best of intentions, like most family disasters do. The year was 2001. My son Michael had just married Alina. He was a bright young engineer. She was a driven real estate agent. They wanted to put down roots, but Phoenix's housing market was already climbing. As a father, and as a man who'd made his own money in commercial construction, I saw an opportunity. Not a gift, but an investment in their future. I paid the $180,000 down payment on a 4-bedroom home in a promising Scottsdale neighborhood. The mortgage was in my name. The deed was in my name. We had a simple, gentleman's agreement. Michael would cover the monthly payments, essentially paying me rent, and after 10 years we'd transfer the title to them for $1. It was a handshake deal, a family trust exercise. I even moved into the detached guest house on the property to be close, to help with future grandchildren. For a decade it worked. Michael made his payments, I handled major repairs, Alina decorated, we were a unit. The first crack appeared in 2011, right on schedule, the 10-year mark. The real estate crash had cratered the home's value, but our agreement stood. I sat them both down at my kitchen table, the original handwritten terms between us. "All right," I said, sliding the paper forward. "Time to make it official." Alina's smile didn't reach her eyes. "James, with the market the way it is, transferring title now could have terrible tax implications for us. It's better to wait for the rebound." Michael nodded along, avoiding my gaze. "Dad, she's right, it's just paperwork. What's the difference?" The difference was the agreement, but I let it go. The market would recover. Family harmony was worth more than a line at the county recorder's office. That was my first mistake. I didn't know then that in property law, delay is a strategy, and Alina was a strategist. The rebound came, then a boom. By 2018, that house was worth over $1.2 million. My quiet, unassuming guest house was now sitting on a goldmine parcel. Alina's career skyrocketed with the market. Her clientele became wealthier, her tastes more expensive. Subtle renovations began. First, it was a kitchen update. "Just modernizing, James. You won't even notice the workers." Then the landscaping was completely overhauled. My desert-friendly yard replaced with thirsty, elaborate greenery and a water-guzzling fountain. Each change was presented as a asterisk fait accompli asterisk, a discussion after the fact. My role shifted from co-owner to tenant, a privileged one but a tenant nonetheless. I'd hear her on the phone in the main house, her voice carrying through the open windows. "Oh, the guest house. Yes, my father-in-law lives there. It's a sweet arrangement for him." Sweet. Like I was a pet in a luxurious kennel. Then came the suggestions, gentle at first. "You know, James, there's a wonderful active living community just 10 minutes away. Swimming pools, bridge nights." Then more direct. "Michael and I are thinking of expanding the main house, an extra wing. The guest house, it's in the perfect footprint." The message was clear. The asset had matured and the original investor was now in the way. The family dynamic curdled into a quiet, cold corporate takeover. Dinners became strained. Conversations revolved around their equity, their plans, their future. My history with the property, the initial capital, the 2 decades of tax and insurance payments I'd covered, erased. I was living in a story they were rewriting, and my character was being phased out. The final turn was the grandchildren, or the lack thereof. For years, my presence was tacitly justified by the promise of helping with a future family. It was the emotional core of our 3-generation arrangement. But as Alina climbed into her late 30s, the subject became a landmine. Once, over a tense Sunday barbecue, I made an offhand comment about the neighborhood kids. Alina put her wine glass down with a sharp asterisk click asterisk. Our life choices are not a topic for discussion, James. The temperature at the table dropped 20 degrees. Michael stared at his plate. That night, I realized the unspoken truth. I wasn't waiting to help with grandchildren. I was waiting for an excuse to leave, and they had no intention of giving me one. The pressure escalated from atmosphere to action. Last Thanksgiving was the dress rehearsal. Alina handed me a printed itinerary. To keep the day smooth, she said. My assigned task was to arrange the outdoor seating and then stay out of the kitchen. I was a logistical problem to be managed. During dinner, she held court, telling her friends about the property and its potential, her eyes sliding over me as if I were a piece of the furniture she planned to replace. Michael said nothing. His silence was the loudest sound in the room. I went back to my guest house that night with a hollow, cold certainty. The handshake deal was dead. The family facade was crumbling. I was a ghost in my own investment. But the true earthquake, the event that tore the last veneer of civility away, was the email. It arrived on the Thursday before Easter. The subject line, Easter gathering details. It was a mass email sent to extended family and friends. I scanned it. Menu, arrival time, dress code. At the very bottom, in a separate, bolded paragraph, it read, "Please note, due to space constraints and a desire for an intimate nuclear family moment this year, the guest house will not be hosting additional guests. We appreciate your understanding." Additional guests, space constraints. In a 4,000 square foot home, the message wasn't subtle. It was a public, formal eviction from a family tradition. She hadn't even had the courage to say it to my face. She'd copied the world on my dismissal. I read it 3 times, the words blurring on the screen. This wasn't a suggestion about assisted living. This was a decree of exile. The rage was immediate, a white-hot wire in my chest. But beneath it, something colder and more solid settled. Clarity. For 23 years, I had operated on faith. Faith in my son, faith in a handshake, faith in the word family. Alina had just shown me her faith was in contracts, in control, in assets. She wanted to play that game, fine. But she was about to learn she'd been reading the wrong rulebook. I closed the laptop. I didn't call Michael. I didn't reply to the email. I walked to my filing cabinet, the old, heavy metal one that held a lifetime of paperwork. I knew exactly what I was looking for. The game was on, and I held the winning card. I just had to wait for Monday to play it. The document I pulled from the filing cabinet wasn't just the original deed. It was the founding document of the Callahan Family Property Trust, dated March 15, 2003, 2 years after I bought the house. I had never transferred the title to myself personally. I had placed the entire property into an irrevocable trust, with me as the sole trustee and beneficiary. The trust was the legal owner, and I was the only person on earth who could dictate what happened to it. That trust was my secret, my quiet contingency plan drafted after a business partner's ugly family lawsuit. I'd never told Michael. Why would I? It was just prudent asset protection, until prudence became my only weapon. Easter Sunday dawned bright and quiet. I heard the preparations in the main house, car doors, laughter, the clatter of dishes. The intimate nuclear family moment. I didn't peek through the blinds. I sat at my desk with a cold cup of coffee and a list I'd made. 1. Confirm trust status. 2. Consult counsel. 3. Determine options. This wasn't about emotion anymore. It was a project, a hostile takeover defense. At 10:17 a.m., my phone buzzed. A text from Michael. "Dad, you okay? Feel bad about today. We'll do something next weekend, just us." The guilt text, the pacifier. Alina must have approved it. I didn't reply. Silence is also a message. First thing Monday morning, I was in the office of Robert Vance, an estate attorney whose name I got from an old contractor friend. Vance had the weary eyes of a man who'd seen families torn apart over dirt and dollars. I slid the trust documents across his polished desk. "I need to understand my position," I said. He read in silence for 5 full minutes, flipping pages. He looked up. "Mr. Callahan, your position is a fortress. The property is owned by a trust you control. Your son and his wife have no equitable interest, no claim, unless you grant them one. They are, in the eyes of property law, tenants with no lease. What exactly is the situation? I told him the down payment, the handshake deal, the 10-year delay, the renovations without consent, the Thanksgiving itinerary, the Easter email. Vance listened, taking sparse notes. When I finished, he leaned back. So, they've been treating the asset as their own while systematically excluding the actual owner from the family unit. And they're likely operating under the assumption the title is either theirs or will be imminently transferred. He templed his fingers. You have 3 primary legal avenues. 1, you can formally demand they vacate. As trustee, you can terminate their tenancy at will, standard 30-day notice. 2, you can initiate a quiet title action to formally and publicly affirm the trust's ownership, clouding any claim they might try to fabricate. 3, you can sell the property out from under them. The trust owns it. You can list it. The cold, clinical sound of those options was bracing. What about the money my son paid me for 20 years? I asked. Vance shrugged. Rent. Unless you have a written agreement stating those payments were building equity, their rent. He received a service, a place to live for a fee. The trust, and by extension you, provided that service. The moral weight of our handshake deal dissolved in the face of contract law. Michael's payments were just cash flow. The realization was a gut punch. I had built a financial trap for my own son without ever meaning to, but Alina had walked him into it. What's my best first move? I asked. Vance smiled thinly. The notice to vacate, it's a 30-day formal notice. It establishes your authority as property manager for the trust. It's the starting gun. Their reaction will tell you everything. If they panic and try to negotiate, you have leverage. If they retaliate, you escalate to the quiet title action. Either way, you shake the tree and see what falls out. He drafted the notice while I waited. It was a single page of devastatingly dry legalese. To the occupants of 1427 Mesquite Ridge, you are hereby notified that your tenancy at will is terminated. You have 30 days to vacate the premises. I signed it as trustee. The pen felt heavy. I didn't serve it that day. I sat on it. I needed to see Michael alone, to look him in the eye one last time before the war started. I caught him on Tuesday evening as he was taking out the trash. He looked tired. Dad, hey, I tried calling. I know, I said, standing in the driveway. We need to talk about the house, about the agreement. He shifted his weight, uncomfortable. Alina said not to get into it. She says it just stresses everyone out. The market's good. We'll figure out the title thing eventually. There it was. Alina said asterisk. My son, a 45-year-old man, was taking communications directives from his wife about the home I bought him. This isn't about stress, Michael. This is about ownership. My name is on the deed. It always has been. He blinked, confused. Right, but we had our deal. It's basically ours. Basically isn't a legal term, I said, my voice calm. The trust owns it. I control the trust. I watched the words land, watched his mental model of the world fracture. Trust. What trust? So she hadn't even done the basic due diligence. She'd assumed for a decade. The arrogance was breathtaking. Go ask your wife to pull the property records, I said, turning back toward the guest house. Then come talk to me. The explosion happened inside the main house 20 minutes later. I heard the raised voices through my closed windows. Alina, a sharp alto of disbelief and rage. Michael's, a lower, confused rumble. A door slammed, then silence. The Cold War had just gone hot. An hour later, my phone rang. It was Alina. I let it go to voicemail. She didn't leave one. 10 minutes after that, Michael texted. We need to meet, all 3 of us, tonight. I replied with one word. No. The next morning, the notice to vacate was taped to their front door and a copy was sent via certified mail. The 30-day clock started ticking at noon. My hand was played. Now I waited for theirs. It took less than 6 hours. Alina's strategy was predictably emotional warfare. She didn't come to me. She went public. That afternoon, my phone began to buzz with calls from bewildered relatives. My sister, Kathy. Jim, what's going on? Alina called me in tears saying you're evicting them 2 weeks before Michael's birthday, an old family friend. James, I just got a very upsetting call. Is everything okay with the family? She was triangulating, recruiting a chorus of concern to pressure me into backing down. I gave everyone the same brief response. It's a private property matter. I suggest you talk to Michael and Alina for their side. I didn't defend. I didn't explain. I just let the mystery hang there. The following day, the strategy shifted. A sheriff's deputy knocked on my guest house door. Pleasant professional. Afternoon, sir. We received a concern for welfare call at this address. Checking on a James Callahan. A welfare check. She called the cops, painting me as an unstable old man making rash decisions. I invited the deputy in, showed him the trust documents, the notice to vacate. Family dispute over property, officer. I'm of sound mind, just enforcing my legal rights. He nodded, understanding. Happens more than you'd think. Sorry to bother you. As he left, I saw Alina watching from the main house window. Her face was a mask of furious calculation. The emotional and public plays had failed. Now she'd have to engage on the one battlefield I was prepared for, the law. Her lawyer's letter arrived on day 5. Thick, cream-colored paper from a firm named Sterling and Reed. It claimed detrimental reliance. It argued that my son and his wife had invested substantial sums in the property, the renovations, the property taxes they'd occasionally paid when I was short 1 year, 23 years of sweat equity, based on my promise to transfer title. It demanded I immediately sign a quitclaim deed conveying the property to them, or they would sue for breach of contract and seek not only the title but damages. It was a bluff, a good one, but a bluff. They had no written contract. The promise was a family story, but it was the opening salvo in the legal battle I knew was coming. I took the letter to Vance. He read it and laughed, a dry, papery sound. Sterling and Reed, they're divorce attorneys. Good ones, but this isn't their wheelhouse. Detrimental reliance is incredibly hard to prove, especially without a written agreement and especially over such a long period where you continued to hold yourself out as owner. He drafted the response. It was a masterpiece of legal dismissal. It stated plainly that the Callahan Family Property Trust rejected their claims in their entirety. It noted the occupants were now an unlawful detainer after the expiration of their notice to vacate, and it included a counteroffer. The trust would offer them a cash-for-keys deal, $60,000 to vacate peacefully within 10 days and sign a release of all claims. It was an insultingly low number for a $1.2 million home. It wasn't meant to be accepted. It was meant to enrage. It worked. Alina's next move was not through a lawyer. She showed up at my door. It was the first time she'd come to the guest house in years. She was perfectly dressed, perfectly composed, but her eyes were like flint. "James, may I come in?" I held the door open. She stood in the middle of my small living room, not sitting. "This has gone far enough. You're tearing this family apart over a technicality." "It's not a technicality, Alina. It's ownership. Michael has paid into that house for 2 decades. She shot back, "He's your son. Don't you want him to have stability?" "I did want that," I said quietly. "I provided that stability. You mistook it for weakness. You thought you could edit me out of the story. You can't. I am the story." She switched tactics, her voice dropping into a confiding, dangerous tone. "You're alone, James. You're pushing everyone away. What happens when you fall, when you need help? Who do you think will be there? We're your family." It was a threat wrapped in false concern, the final manipulation. "If my family is people who exile me and then threaten me when I assert a legal right," I said, "then I'd rather be alone." The mask slipped completely then. Raw, unfiltered hatred flashed across her face. "You selfish old man, you'll lose. We'll drag this through court for years. We'll bury you in legal fees. You'll die in a courtroom and that house will be ours." She turned on her heel and left, slamming the door so hard a picture frame rattled on the wall. The declaration of war was now explicit. It was no longer about Easter dinner. It was about annihilation. And that's when I discovered I wasn't the only one with secrets. The day after her visit, I got a call from my accountant, Phil. He sounded nervous. "Jim, got a weird request today. A law firm, Sterling and Reed, subpoenaed your financial records related to the Mesquite Ridge property, specifically any records of funds from Michael." My blood ran cold. "What did you do?" "I told them to talk to you and your attorney. But Jim, I had to look. I pulled the files, those payments from Michael. They stopped 3 years ago." I froze. "What?" Yeah, the last automatic transfer was in April 2021. Nothing since. I just assumed you told me to stop tracking it or you had a new arrangement. For 3 years, my son had not made a single payment on the house, not one, and he'd never said a word. Alina's renovations, her lavish lifestyle, they weren't built on their equity. They were built on my silence, on my assumption that our deal was still running. The handshake deal wasn't just dead. They had secretly buried it and were dancing on the grave. The rage returned, cleaner and sharper than before. This wasn't just exclusion or arrogance. This was financial fraud within the family. They were squatting in $1 million asset rent-free while plotting to steal it outright. I called Vance immediately. They haven't paid in 3 years. That changes things, right? His voice was crisp. Dramatically, it eviscerates any claim of detrimental reliance or them holding up their end of any oral agreement. It strengthens your unlawful detainer case. It shows bad faith. But Jim, this gets uglier. If we pursue this, we're not just evicting them. We're potentially setting up a lawsuit for back rent against your son. The room seemed to tilt. Sue my son for 3 years of back payments at market rate. The cold math was terrifying. At current rental values for that home, it could be over $150,000. The path before me forked sharply. One road led to a settlement, a forced negotiation where I could maybe salvage some shred of a relationship with Michael. The other road led through the courts, through financial ruin for them, and the absolute, permanent destruction of my family. Alina had forced me to this choice, but the next move was mine, and I had 24 hours to decide whether to become the villain in their story or to write an ending so final, even they couldn't rewrite it. I didn't sleep that night. The number kept scrolling behind my eyes. $150,000. Minimum, the back rent my son owed the trust. The cold, legal truth was a hammer, but using it felt like swinging that hammer through my own chest. At dawn, I called Vance. File the unlawful detainer, but hold the back rent suit, for now. It was a middle ground. Get them out, establish my authority, but leave the nuclear option in the silo. Maybe, just maybe, it would shock Michael into a real conversation. Vance filed the papers that morning. The sheriff's eviction hearing was set for 3 weeks out. The response was not a conversation. It was a declaration of total war. 2 days later, a process server handed me a thick stack of documents. Alina had filed a cross-complaint. She wasn't just fighting the eviction. She was suing me in my capacity as trustee for fraud, for elder financial abuse, and for intentional infliction of emotional distress. The fraud claim was based on the original promise. The elder abuse claim was a vicious piece of legal theater. She, the younger caregiver, was accusing me, the elder, of abusing her financially by not giving her my property. The emotional distress claim cited the Easter exclusion email as evidence of my campaign of harassment. The sheer, breathtaking audacity of it left me numb. She was using the very act of my exclusion, her act, as a weapon against me. But the real poison was in the supporting declarations. She had gotten Michael to sign one. His statement was a knife to the heart. It read, in part, "My father, James Callahan, has always been controlling with money. He used the house as a way to maintain leverage over our family. His recent actions are a continuation of this lifelong pattern. My own son, under oath, reducing 23 years of support to a pathology, reducing me to a caricature of a manipulative patriarch." He had chosen his side, completely. There would be no secret negotiation, no last-minute reconciliation. The line was drawn in legal cement. Vance was grim when we met. "This is scorched earth litigation. They're trying to overwhelm you, demoralize you, and run up your legal bills, hoping you'll settle for the house just to make it stop. The emotional distress claim is frivolous, but it costs money to fight. The elder abuse claim is dangerous. It triggers mandatory court investigations. This just got very expensive and very ugly. My life's work, my family, was now a line item on a legal bill." The cost of principal was being tallied in real time. Then the second bomb detonated. A week before the eviction hearing, a title search Vance ordered revealed a new lien on the property. Not from me. a home equity line of credit for $250,000 taken out by Michael and Alina just 8 months prior. The loan documents listed the Mesquite Ridge house as collateral. They had borrowed $250,000 against my property, the trust's property. The fraud was no longer just familial, it was criminal. You can't pledge an asset you don't own. My hands shook holding the paper. They hadn't just stopped paying. They were actively monetizing the asset, treating it like an ATM, with total confidence that their theft would never be discovered. Vance's voice was tight with fury when I called him. "This is felony fraud. We have to report this to the lender and the district attorney. Immediately. If we don't, the trust could be liable if they default." The decision was taken out of my hands. The law had its own momentum now. Vance filed a notice of fraudulent lien with the county recorder and sent a formal letter to the bank, Silvergate Financial, informing them their collateral was owned by a trust and the borrowers had no legal right to pledge it. The fallout was instantaneous and catastrophic. For them, Silvergate Financial froze the line of credit and demanded immediate repayment of the full $250,000. They also filed a lawsuit against Michael and Alina for fraud. The district attorney's office opened a preliminary inquiry. The comfortable life Alina had built on a foundation of assumptions collapsed in 48 hours. I learned all this not from them, but from a reporter from the local business journal who called me for comment. "Mr. Callahan, we're doing a story on a fraud case involving a high-end Scottsdale property and a local real estate agent. Can you confirm you are the actual owner?" The scandal was now public. Alina's professional reputation, the currency of a real estate agent, was evaporating. The night the story broke online, Michael came to my door. He looked hollow, aged a decade in a week. No Alina in sight. "Dad," his voice was ragged. "You have to call off the dogs. The bank is suing us. Alina's brokerage is investigating her. This is ruin." I looked at my son, this stranger full of fear. "Call off which dogs, Michael? The bank I didn't ask to loan you money, the DA I didn't call. You committed fraud. You lied on loan documents. You sued me for elder abuse. You set these dogs loose yourself. You just never thought they'd bite you." He broke then. The facade of the successful engineer, the obedient husband, crumbled. He sagged against the doorframe. She said it was just a formality, that you'd never find out, that we'd have the title long before the loan came due. She said you were old, that you'd forget. He was crying now, quiet, hopeless tears. "I was scared, Dad, scared of losing her, scared of the debt. I just went along." In that moment, I didn't see a villain. I saw a weak, terrified man who had traded his father for peace in his marriage and was now losing both. The anger in me cooled into a profound, weary sadness. "You have a week before the eviction hearing," I said, my voice empty. "Get a lawyer, a real one, not a divorce attorney, and for God's sake start telling the truth." He left. The moral victory was ashes in my mouth. I had proven my point. I had protected the asset, and I had destroyed my son. The house was a fortress, and I was a king ruling over a scorched kingdom. But Alina wasn't finished. Desperation makes people inventive. Her next move was a masterstroke of malice. She filed for a temporary restraining order against me, not for violence, for harassment. Her claim, that my campaign of legal terrorism, including filing the lawful eviction and reporting the fraud, was causing her severe emotional distress, impacting her ability to work. She included the reporter's article as evidence that I had leaked the story to destroy her. The hearing was set for 2 days later. Sitting in that family court, waiting for my name to be called, was the deepest humiliation of my life. I was 72 years old, being treated like a stalker because I wanted to keep my own property. The judge, a no-nonsense woman in her 50s, listened to Alina's attorney paint a picture of me as a vengeful, wealthy patriarch using the legal system to punish his daughter-in-law for a minor family disagreement. Then Vance stood up. He didn't raise his voice. He simply entered into evidence the trust documents, the fraudulent loan paperwork, the cease and desist letter from the bank. He walked the judge through the timeline. The Easter email, the eviction notice, the discovery of the fraud, the necessary report to the bank. Your Honor, he concluded, the petitioner is not a victim of harassment. She is a perpetrator of fraud facing the consequences. The respondent is defending his property rights through standard, lawful channels. The judge looked from Alina's weeping performance to the paper trail in front of her. She denied the restraining order, emphatically. Then she did something extraordinary. She looked directly at Alina and her lawyer. Counselor, based on what I've seen today, your client is fortunate she is not facing criminal charges from this court's perspective. I suggest she focus her energies on resolving her very serious financial and legal problems, and not on wasting this court's time with frivolous filings. It was a public, judicial gut punch. Alina left the courtroom white-faced, not looking at anyone. We had won the battle decisively, but the cost was absolute. That evening, as I sat in the silent guest house, the weight of it all settled on me. I had my house. I had the law on my side. I had won, and I had never felt more utterly alone. The victory was a hollow, echoing room. The family was gone. My son was broken. The future was just me, this property, and a lifetime of legal memories. I had set out to prove a point about respect and ownership. I had ended up proving a darker point about how far people will go and how much they will burn to possess what they believe is theirs. Then the final envelope arrived. It wasn't from a lawyer. It was from a different firm, a forensic accounting group hired by the bank. They had completed a preliminary audit of Michael and Alina's finances. Vance forwarded it to me for context. I almost didn't open it. What more could there be? I was wrong. The report contained a transaction that stopped my heart. 6 months ago, a wire transfer for $45,000 from their home equity line of credit, from my property, to an account in the Bahamas. The beneficiary was a shell company. The accounting firm's note read, "Transaction bears hallmarks of asset concealment, likely related to pending marital dissolution." The pieces clicked together with a final, sickening certainty. The loan wasn't just for lifestyle or debt. Alina wasn't just planning to stay and fight me for the house. She was planning her exit. She was siphoning money offshore, preparing to leave my son, leave the country, and leave him holding the bag for a $250,000 fraudulent loan and a lawsuit from his own father. The marriage, the fight over the house, it was all a smokescreen for her getaway. And Michael, my loyal, weak Michael, was about to be left bankrupt, legally exposed, and utterly alone. I looked out the window at the main house, dark and silent. I had won the war for the bricks and mortar, but the human cost was now a tidal wave rushing toward my son, and I was the only one who saw it coming. The legal battle was over. The real rescue mission was about to begin, and it would require me to do the one thing I never thought I'd consider: surrender the very thing I had fought so hard to keep. I didn't go to Michael that night. I went to Vance with the forensic report in my hand. "We need to stop her," I said, my voice flat. "Not for me, for him." Vance studied the Bahamian wire transfer record. "This is bank fraud and probable wire fraud. If we give this to the DA, she's looking at real time. But Jim, if we do that, Michael could be implicated as a co-conspirator. He signed the loan docs." The trap was perfectly constructed. To save my son from financial ruin, I might have to send his wife to prison and possibly take him down with her. There was no clean path, only a choice of catastrophes. I chose the only third option I could see, a trap of my own. I called Michael and told him to come to the guest house. Alone, no lawyers, no Alina. He arrived looking like a ghost. I didn't offer sympathy. I placed the forensic report on the table between us. "Do you know about this?" He read it, his face blank with confusion, then slow dawning horror. "The Bahamas, no. This was for the kitchen expansion." She showed me bids. His voice trailed off as he understood. "The kitchen expansion that never happened. The money that vanished. She's leaving you, Michael, and she's taking everything that isn't nailed down and leaving you with the debt." Lumped in the chair, utterly defeated, the last of his defenses crumbled. What do I do? In that moment, he wasn't my adversary. He was my child, scared and lost. "You do exactly what I tell you," I said. "First, you hire your own criminal attorney today. Second, you file for legal separation immediately, citing financial misconduct. It might protect you from some liability. Third, you give me full power of attorney to negotiate with the bank on your behalf. He looked up, wary. Why would you do that? Because, I said, the words bitter in my mouth, despite everything, you're still my son, and I won't let her destroy you. The next 72 hours were a blur of brutal transactional negotiations. With Michael's power of attorney, I met with Vance and a lawyer from Silvergate Financial. The bank didn't want a scandal. They wanted their money. I made an offer. The Callahan Family Property Trust would pay off the $250,000 fraudulent loan in full. In exchange, Silvergate would drop their lawsuit against Michael and agree not to refer the case for criminal prosecution. They would also provide a sworn statement that Michael had been misled by his spouse regarding the ownership of the collateral, a tiny sliver of plausible deniability for him. The bank, seeing a guaranteed recovery, agreed. The price of saving my son from prison was $250,000 of the trust's money. I wrote the check. It was the easiest hard decision I ever made. With the bank neutralized, I turned to Alina. I had Vance send a letter to her attorney. The terms were stark. 1. She dismisses all lawsuits against me and the trust with prejudice. 2. She vacates the Mesquite Ridge property within 72 hours. 3. She signs a notarized statement admitting she knew the trust owned the home when she secured the loan. In return, the trust would not file a civil suit against her for fraud, and I would not provide her Bahamian wire transfer records to the district attorney. We would also not oppose her divorce filing or make claims on her separate assets. It was a buyout of her silence and her departure. She was being given a narrow escape hatch, but she had to leave everything behind. She fought, of course. Her lawyer blustered about defamation and extortion. Vance remained immovable. Our next call is to the white-collar crime unit at the DA's office with these wire transfers. Your client has 24 hours to decide if she prefers our deal or federal indictment. She signed. On a Tuesday morning, I watched from my window as a moving truck pulled up. Alina supervised, stone-faced, as movers loaded her furniture, her art, her wardrobe. She didn't look toward the guest house once. Michael was not there. He was staying in a hotel, paralyzed by shame. By sunset, she was gone. The main house stood empty, echoing with 23 years of a life that had just been legally and physically erased. The eviction hearing happened without the occupants present. The judge granted the unlawful detainer order. The sheriff posted a notice on the door. The property was officially, undeniably mine again, but it felt like a tomb. I walked through the empty rooms. The renovations Alina had been so proud of felt garish and hollow. The silence was absolute. I had won. I had the deed, the trust, the legal victory, and I stood alone in a 4,000-square-foot monument to a family that no longer existed. A week later, Michael asked to see me. We met in the empty living room of the main house, sitting on the bare floor. He handed me a folded check. It was for $40,000, every penny he had left in his personal savings. It's not enough, it's not even close, but it's a start, he said, his eyes on the floor. For the back rent, for everything. I looked at the check, then tore it in half. He flinched. I don't want your money, Michael. I never did. I wanted your respect. I wanted you to be a man who honors his word. He started to cry, silent, shoulder-shaking sobs. I'm sorry, Dad. I am so sorry. For the first time in years, it sounded true. We talked for hours in that empty room. He told me about the pressure, the constant financial anxiety Alina cultivated, her disdain for him that grew with every year they didn't own the house. He confessed he knew the payments had stopped, but she had convinced him I was so wealthy I wouldn't notice, that it was a form of estate planning. He was a coward. He admitted it. I didn't argue. But I saw, for the first time, the frightened boy inside the middle-aged man, the one who had always sought a stronger person to follow. First me, then her. I made one final decision as trustee. I drew up new documents. I dissolved the Callahan Family Property Trust. I transferred the title of the Mesquite Ridge house to a new entity, a limited liability company. I owned 51%. Michael owned 49%. The operating agreement was 20 pages long, ironclad. It outlined responsibilities. He was responsible for all mortgage payments, taxes, insurance, and maintenance. He could live in the house. He could not borrow against it. He could not transfer his interest without my approval. Upon my death, my 51% share would pass to a charity for first-time homebuyers, not to him. It was not a gift. It was a probation, a long, difficult path to eventual ownership if he could walk it. I presented it to him. This is the last deal I will ever make with you. There is no handshake. There is only this paper. Sign it, or I sell the house tomorrow and you find an apartment. He read every word. He signed. It was the beginning of a new, brittle, business-like relationship. We are not the family we were. We probably never will be, but we speak. He makes his payments on time. He sends me the bills for review. We have coffee every other Sunday. It's strained, but it's real. The trust is gone, but a different, more cautious trust is being built, word by word, payment by payment. As for the guest house, I moved out. I sold it to a young couple, the daughter of my old accountant and her husband. I sold it cheap with a rider that the main house could not obstruct its view. It was my final twist on the deed. Michael now has neighbors who are technically my allies, a gentle reminder that he is not alone on that land. I moved to a smaller, modern condo in a building with a pool and a gym. No guest houses, no memories in the walls. The silence there is my choice. Final surprising detail came from Vance. 6 months after it was all over, he called me, chuckling. Remember that quitclaim deed Alina demanded you sign at the beginning? I was cleaning out the file. I noticed something in the footer, the document template she used. It was from a website called DIYlegalforms.com, the $15 version. After all the bluster, the lawsuits, the fraud, the international wire transfers, her first legal salvo was a cut-rate downloaded form. She was always bluffing. She just never thought I'd call. I own the house. I have a fraught but functioning relationship with my son. And I finally understand that the most powerful clause in any contract isn't written on paper. It's written in the willingness to walk away. I was finally ready to walk, and that's what saved what could be saved. The property revelation did demolish her sense of security. But in the end, it rebuilt something else, something smaller, harder, and more honest. Not a family home, but a peace treaty. And for now, that's enough. So what is the true cost of a deed? For me, it was 23 years of a family, $250,000 in legal fees and bank payoffs, and a relationship with my son that is now more of a cautious business partnership than a bond of blood. I live in my quiet condo. Michael lives in the house, under the strict terms of our operating agreement. We have Sunday coffees that are more like board meetings. It is not what I envisioned when I wrote that down payment check in 2001. But it is what remains after the storm. The story of a patriarch, a daughter-in-law, and an Easter exclusion is really a story about the silent contracts we make within families. The contracts of expectation, of obligation, of future promises. My fatal flaw was believing my handshake was as binding as my trust documents. Alina's fatal flaw was believing my silence was consent. We were both wrong, and my son paid the price for both of our failures. Property law is clear. Emotions are not. You can own every square foot of dirt and every brick in the wall and still lose the home that was built there. The deed was just paper. The family was the real structure, and we all worked together to demolish it. I got my name on the house back, but I will never get back the years where that house was simply a home with a family inside it that included me. This is the uncomfortable truth these stories reveal. Sometimes you have to choose between being right and being connected. Sometimes enforcing a boundary means building a wall you can never cross again. I proved my point. I secured my asset. And in doing so, I learned that the most expensive thing you can own isn't property. It's a victory that feels like a loss. If this story resonated with you, if it made you think about the unspoken agreements in your own life, then like this video. Subscribe to the channel for more deep dives into the conflicts where family, money, and law collide. Share your thoughts in the comments below. Have you ever seen a family rift over property? What would you have done differently? Your perspective is part of the conversation. Because these aren't just stories about houses and deeds. They're blueprints for the wars we fight with the people we're supposed to love and the peace we're left to build in the aftermath. The next time you sit at a family dinner, look around the table and ask yourself silently, what are the real terms of our agreement? The answer might just save you a fortune and a family. Thank you for listening.